justice delivery system in the country. So much just going on, so quick. I mean, you just heard about that in the papers about John Yakubu and what people are saying about Justice Talba. And then yesterday, you also heard about the Dutch court ruling on some farmers from Nigeria over there. Well, we're joined now by Mr. Akiri, who is a legal practitioner and an author and the chairman editorial board of National Daily Newspapers. Thank you for coming on this morning.
It's my pleasure.
Well, when seeing this, first of all, were you surprised at the judgment? Because some lawyers said they are. Were you also surprised at that judgment of John Yakubu?
No, I was not surprised, to put it bluntly.
Why?
I wasn't surprised. Good. One has to approach this question. Well, you know, use a double-pronged approach to answer this question. Number one, I look at that question from the point of view, the popular point of view, the point of view of popular opinion. That's number one. And then secondly, I look at it from the angle of vision of the law. So maybe you allow me to approach it first from the popular point of view.
Okay.
That is to say that in this country, corruption is rife. It is endemic. It is systemic. And it's baneful. You know, the bane of Nigeria's political, socio-economic development is corruption. Remove corruption and we will be almost like a superpower. But how do we remove it? You know, with the weak-kneed approach, you know, that successive governments have used to attack it, is nothing to write home about. So what do? I mean, particularly when a matter like this has come and there's an opportunity to discipline somebody who has stolen so much, and in fact he admitted to have stolen so much, 23.3 billion naira. You know, I know it's an opportunity to discipline him and, you know, let it serve as a deterrent to other people. What have we done? I mean, we just gave him a slap on the wrist and then let him go. So how do we attack, you know, this thing, corruption? So that is the popular approach. You know, that's the popular opinion. We would attack it like this. But if you look at it from the angle of vision of the law, you asked me, was I surprised? I said no. You look at it from the angle of vision of the law, then you wouldn't be surprised. Because the man, John Yakubu Yusuf, was arraigned before the Abuja High Court under the provisions of the section 309 of the Penal Code of the Federal Capital Territory, Abuja, 2007. Now, I have brought the law under which he was charged, and this is the law. If you allow me to read it briefly, it says, section 309 of the Penal Code of the, you know, Federal Capital Territory, Abuja, 2007, under which he was arraigned before that court, said, whoever commits criminal misappropriation shall be punished with imprisonment for a term which may extend to 2 years, or with fine, or with both. Unquote. So, when you have that type of law, now, since the days of Hans Kelsen, the man who introduced positivism into the legal system, now law is viewed from, you know, is viewed from the perspective, is viewed or interpreted do lege lata, if you will permit me, do lege lata. That is the way it is, and not the do lege ferenda.
The way it ought to be.
That the way it ought to be. Good. So, and that's the law. Now you heard when I read that the person may be, you know, any person who is guilty of misappropriation, criminal misappropriation, may be sentenced to imprisonment for 2 years, the imprisonment may be extended to 2 years, or with fine, or with both. Now there's what we call judicial discretion. You see, judicial discretion means in this particular case that where the law has said may extend it to 2 years.
Yeah.
You may decide to give him 1.5 years or 1 year with fine or without fine or with or both, and you may decide to give him the full, sentence of 2 years. That's what we call judicial discretion. Judicial discretion does not mean that you go completely away outside the realm of the law. Because if you do that, you will be guilty of judicial rascality.
Did he go completely outside the realm of the law?
No, I mean, but that's what he did. He was within the realm of the law. In fact,
when we talk about within, in other words, the judge could have as well given maybe a 6-month sentence.
Yes, he could do that because that's what the law is saying. But in exercising his own judicial discretion, he gave him the maximum sentence of 2 years because that's the law. We expect that, this man should have got 20 years or 15 years to be happy. But that's not what the law says. You see, he has exercised it, he has viewed this law, he has interpreted this law, do lege lata, the way it is. He couldn't have gone beyond this point. Even if we all felt that, this man should have been... he should have gone to prison for 23.3 billion. He should have gone to jail for 10 years or 20 years and so on. So on. But that's not what the law is saying.
Now, it got me thinking, why did the EFCC decide to charge him under the Penal Code when aren't there alternatives, knowing full well that this is the maximum that he will likely get when he goes through this process?
Yes, correct. You see, in fact, the solution to this problem, from your question, would be that the National Assembly should amend these laws, both the Penal Code Act and the Criminal Code Act governing the South. Because if you go through the codes, either the Penal Code or the Criminal Code, you won't see anything dramatically different from what you are seeing now. There are places where they say, okay, the fine will be 200 naira. The fine will be 500 naira. The fine will be 1 year, and it doesn't go beyond that. In fact, it's only the EFCC Act, the man has been rearrested. Yes. And he's been rearrested under the provisions of Section 27 of the EFCC Act 2004. Now, that one attracts a sentence of, if he's convicted, then he is going to go in for at least 5 years. Without the option of a fine, because that provision is not saying there is any option of a fine.
For non-declaration of assets.
Correct, non-declaration of assets. That one attracts at least 5 years, and without the option of a fine. Now, but that's different. All the other ones, both in the Criminal Code, if you had committed the offense in the South here, and in the Penal Code, you don't have anything more than this one. The judge just exercised his discretion by giving the maximum sentence of 2 years plus a fine.
So for the avoidance of doubt,
yes,
if anyone commits such crime and
yes,
is tried under that code, the maximum sentence is 2 years.
It's 2 years.
Or with an option of fine.
With an option of a fine.
And in this case, an option of fine could even be as low as 100,000.
Anything. He has to decide. He has to look at it from the amount of money involved and so on. But he should not go beyond what the Penal Code is saying. Because, even if it's now 23-point-something billion naira and so on, and then he says fine is 1 billion. No, you can't do that.
But the Penal Code, the Penal Code didn't say anything about the amount of any limits to the fine that can be given.
Yes.
So why can't he say 1 billion naira?
No, he can't say that because, first of all, he has to take so many things into consideration. That is, the properties recovered from this person, because there was this plea bargaining aspect of the whole trial. Now, he had volunteered, or at least they looked at what he had, what he built up with the stolen wealth, and then they, impounded everything, including 32 properties, landed properties, and then you know, there was cash of 325 million naira, and so on, all of these things recovered from him.